to secure a meaningful and sustainable independent existence of the judiciary in these times most momentous, failing which we as a nation run the real risk of squandering a historic opportunity at ensuring the systemic entrenchment of the rule of law and democratic governance. Ladies and gentlemen, as I address the nation on 22nd of June 2025 from the podium of the National Seminar on Judicial Independence and Efficiency, Syed Ishtiaq Ahmed, who I will refer to the rest of my address as SIA, SIA's omnipresence was undeniable. Dubbed the chief architect of the underlying philosophy of the Masder Hossain case, SIA's visionary outline for the separation of the judiciary from the executive provided indeed the skeletal framework for my address. After more than 2 decades of his passing, SIA remains the guiding force, therefore, not only for the establishment of a separate secretariat for the Supreme Court, but also the vital reference point for this nation to revisit the broader and diverse issues of the structural and operational architecture of the Supreme Court within, and so on and so forth. SIA's critically central role played both in the outcome of the 8th Amendment case, the Anwar Hussain Chaudhry case, and in devising the neutral, non-party caretaker government mechanism, as chronicled in his posthumously published autobiography, the Ishtiaq papers, comes immediately to mind in this regard. Accordingly, ladies and gentlemen, 22nd June 2025 serves as a turning point in the Supreme Court's institutional history. It marks a continuum and an essential link between the high points, indeed the apogee of constitutionalism in this country, scaled by itself, the judiciary, guided in turn by the likes of SIA, Dr. Kamal Hussain, Barrister Amirul Islam, and the present transformative phase of institution and indeed state building that all of us today are engaged in. The significance, too, of the fact that I, on the 22nd of June, shared the dais with my guest, the Honorable Chief Advisor of the Interim Government, Professor Mohammed Yunus, SI's fellow advisor in the 1996 caretaker government, was not lost on me. In my capacity as the Chief Justice of Bangladesh, tasked to bring the broader vision of the Masder Hussain case to fruition. Destiny may yet have the final say, on how constitutional history and constitutionalism shall complete a full circle overall, informed by SIA's legacy. Indeed, as a dear friend of mine poignantly remarked on SIA's 22nd death anniversary on 12th of July, and I quote him, "It is truly inspiring to see his foundational work on the separation of powers, judicial independence, and democratic transitions coming to guide national discourse and institutional reforms even decades after his passing." That said, today's memorial event aligns with a critical juncture, yet again, in the judiciary's constitutional history. My singular effort at securing institutional autonomy, chiefly through the establishment of an independent secretariat for the Supreme Court, having far-reaching consequences thereby on the tenor and purport of Articles 109 and 116 of the Constitution, has yet again given cause for us as a nation to revisit the broader vision of the Masder Hossain case. That exercise invariably and pertinently so, given the agenda of today's discussion event, leads us to deconstruct SIA's own vision, uniquely so, if I may add, of how the separation of the judiciary from the executive could best be achieved. Ladies and gentlemen, SIA sought in this regard to work with the tools already available within the constitutional dispensation, chiefly within the mandates provided in Articles 109 and 116, allowing, in his view, for a cohesive interplay of both articles, which he believed could best achieve institutional autonomy for the judiciary. It is in that regard that SIA argued that the word, quote-unquote, control in Article 116, read with Article 115, includes the rule-making power of the President in consultation with the Supreme Court in respect not only of posting, promotion, grant of leave and discipline, but also the entire gamut of terms and conditions of service of persons employed in the judicial service and magistrates exercising judicial functions. He contended further that the word control, used in both Articles 109 and 116, has to be reconciled primarily by interpreting the word control to mean not only control over the courts and tribunals, but also over their presiding officers. This was his vision of the independence guaranteed in Article 116A, failing which, he warned, Articles 116 and 116A would be reduced to being mockingbirds only. That apprehension in his mind, ladies and gentlemen, I would propose, arose and still arises as our experience attests to within the present scheme of the Constitution, in which Articles 48(3) and 55(2) play pivotal roles in the conjoint exercise of power by the head of state and the head of government when it comes to matters concerning the judiciary. SIA's metaphorized warning of Articles 116 and 116A, reduced to mere mockingbirds, has come true whenever the element of greater institutional presence of the judiciary as a co-equal organ of the state could not be secured in this essential triangular relationship. It is in that regard that Chief Justice Mustafa Kamal sought recourse to Dr. Kamal Hossain's argument in the Masder Hossain case that the words, and quote, in consultation with the Supreme Court, as you find in Article 116, serves as a pillar which held up the independence of the judiciary as a basic structure of the Constitution. It is here that the 9th Chief Justice of Bangladesh, Chief Justice Mustafa Kamal, remarks, and I quote, "In order that this pillar may not end up as a bamboo pillar, the word consultation has to be given some teeth. Or else, as Syed Ishtiaq Ahmed rightly pointed out, Articles 116 and 116A will be only mockingbirds." What is that teeth? The Chief Justice asked himself. Are mere meaningful and substantive consultations and full disclosure of all connected facts during consultations enough? These are no doubt essential and necessary requirements in the process of consultation, but the end result shall be the primacy of the views and opinion of the Supreme Court, which the executive shall not disregard. For it is the Supreme Court, not the political executive, which is the best judge of judicial matters and judicial officers, end quote. History, ladies and gentlemen, has, however, taught us that the prospects of meaningful and substantial consultations have the tendency to run hollow without an institutional framework to bolster its significance. This is because there is yet a greater dichotomy deeply embedded within the Constitution that troubled the court in the Masder Hossain case. So much so that the court found itself constrained to travel beyond the painstakingly constructed organic relationship between Articles 109, 115, 116, and 116A by the likes of SIA, Dr. Kamal Hossain, and Barrister Amirul Islam, as I have already alluded to and referred to above. The court in the Masder case was hard pressed to locate the core basis of this elusive judicial independence that these three titans of the bar submitted to be built in within the present constitutional dispensation. That exercise led the court in the Masder. That exercise led the court in the Masder case to go off on a slightly different tangent, finding thereby that the absence of any positive language within the Constitution to that effect, that there is this, somehow this core thesis of judicial independence and this guarantee of judicial independence is, embedded in the Constitution, the court couldn't find it readily. To that effect, the court could not locate any mandate given to the president to frame rules under Article 116, covering an entire range of an ever-growing area of judicial institutional ecosystem and activity. Wow. It is within that broader context that Chief Justice Mustafa Kamal arrived at a finding of a structural anomaly within the Constitution, which he succinctly declared to be thus, and I quote him again. In Article 109 of our Constitution, the High Court Division has been given superintendence and control over all courts and tribunals subordinate to it. In Article 116, the control and discipline of persons employed in the judicial service and magistrates exercising judicial functions has been vested in the President, who shall exercise the same in consultation, not with the High Court Division, but with the Supreme Court. Our Constitution, therefore, makes a difference in the subject matter and authority of control and vesting. The courts and tribunals will be under the superintendence and control of the High Court Division, being subordinate to it. But the control and discipline of persons employed in the judicial service and magistrates exercising judicial functions is vested in the President. This distinction stares us in the face. There is a diarchy in our constitutional scheme. Pure and simple. End quote. That is when, distinguished guests, matters stand today as the judiciary since July-August 2024 negotiates closely with this interim government 26 years on to settle the matter once and for all. Of judicial independence. In this, the interim government has over the past 11 months been ably and duly aided by the judiciary itself at every step of the way to undertake meaningful steps in the journey to this institution's autonomy. Distinguished guests, my judicial reform roadmap, unveiled on September 21st, 2024, is our comprehensive blueprint for institutional transformation, placing independence, integrity, and accountability at its very heart. Among the key initiatives we have vigorously pursued are: 1, the Supreme Judicial Appointment Ordinance of 2025. This landmark legislation, a direct response to the call for depoliticization, establishes an independent council for appointing judges to the Supreme Court. For the first time ever, not only in our institutional history, in this nation's history, we are actively creating a transparent, merit-based mechanism insulating these critical appointments from political interference. Thank you. Number 2, establishment of a separate secretariat for the judiciary. This is a foundational step towards achieving true administrative and financial autonomy. As I have consistently emphasized, justice cannot be carried forward on borrowed infrastructure or delegated authority. It must stand on its 2 institutional legs. This secretariat shall empower the judiciary to adopt a holistic approach at framing its own policies. Number 3, restoration and full operationalization of the Supreme Judicial Council. With the disposal of the 16th Amendment review case, the Council has been fully restored. This body is now actively, even as we speak, fulfilling its constitutional mandate to ensure judicial accountability and discipline, a vital component of our independence. Number 4, development of depoliticized posting and transfer guidelines. We are working to ensure that the careers of our judges are guided by merit and fairness and not by external pressures. These guidelines are crucial for safeguarding the impartiality of the district judiciary. 5, enhancing procedural efficiency and accessibility. While seemingly administrative, initiatives such as streamlining family court processes, embracing digitalization, and establishing a judiciary helpline are vital and have indeed caught the imagination of an entire nation and generation of movers and shakers, both within the judiciary and beyond it. An efficient judiciary builds public confidence and ensures that justice is not only fair, but also timely and accessible to all, particularly the most vulnerable. And number 6, strategic engagement with partners. We are actively collaborating with international development partners like the UNDP, the European Union, the United Kingdom, Sweden, and others. Their technical expertise and support are invaluable as we align our reforms with global best practices. These are not mere declarations of intent. These are concrete steps towards building a judiciary that is truly insulated from political interference and grounded in the service to the people. Yet, the path to full judicial independence is not without its formidable challenges. We must therefore be candid about the blockers that impede our progress, of which two stand out prominently. Number one, resistance from entrenched interests. Decades of intertwined political and judicial interests have created a deeply ingrained culture. There will inevitably be resistance from those who benefit from the status quo. And bureaucratic inertia can slow down even the most well-intentioned reforms. And number two, the need for sustained political will across all branches of government. While the interim government has shown some interest, the long-term success of the reform endeavor that we embarked on in September 2024 does hinge on sustained political will from all branches of government. This requires not only a shared vision for a truly independent system, but a national consensus to be forged, and especially at this transitional stage in this nation's history. Ladies and gentlemen, in conclusion, paying my homage to SIA, I reiterate my plea to the interim government, as I did a month ago on 22nd June, and indeed to the nation, to secure a meaningful and sustainable independent existence of the judiciary in these times most momentous, failing which we as a nation run the real risk of squandering a historic opportunity at ensuring the systemic entrenchment of the rule of law and democratic governance, as well as by our apathy to change, endangering the sustainability of all other sectoral reforms proposed to be undertaken by the interim government in the near to the distant future. Thank you very much.